This is the Mobile Home Park Lawyer Podcast with Ferd Neiman. If you're looking to generate wealth and passive income in the lucrative world of mobile home parks, you're in the right place. You'll discover solutions to the common legal and operational pitfalls and how to optimize parks to maximize income. Your host is in the trenches. He's a real estate attorney, financial analyst, and mobile home park investor and operator. Now, let's turn it over to Ferd Neiman.
Welcome back, Mobile Home Park Nation. Tonight I'm going to wrap up my mini-series here on how to utilize the best of your property via rezoning, CUP, or variance. And these are all ways to utilize the property really with opposition from a city code provision or a city staff, an alternative to fighting them on grandfathering. And sometimes you don't have good grandfathering, so you got to come back for one of these three methods. So I've touched on it a little bit in the other episodes, so I'll try to be brief on this, but I want to just talk about the process and kind of the review standard if you end up having to fight the city through like a lawsuit or something down the road. And I got a couple stories that have happened recently with clients where some people didn't make right decisions, that were our predecessors in interest, and it's really harmed us in our arguments at this point. Typically, you want to talk to staff, city staff, and they'll give a recommendation, and they'll tell you where the process is. Typically you got to go, meet with staff. They have something called a review meeting or a development committee meeting or a pre-application meeting. And they tell you all the do's and don'ts and problems. And you want to make sure you read the code and make sure that by applying for something like a rezoning, you're not waiving any grandfathered rights if you potentially do still have them. But typically you go to staff, and then depending on the process, the staff may forward you on to a plan commission. Typically a rezoning or a CUP, you're going to go to a plan commission, then ultimately the city council. A variance request typically would go to a board of zoning adjustment or Board of Zoning Appeals. Some cities, they change that. That's going to depend on the local law, but typically the BZA is supposed to be like an alternative route from the politicized route of the city council. And the Plan Commission, again, is a volunteer group of citizens within the community. They just make recommendations to city council. They don't have a ton of power. And now they can paper the record with, look, this rezoning should not be allowed for these reasons. Well, if the politicos end up approving it, you might be spot zoning, you might be subject to some later challenge. Ultimately, the city council typically makes the decisions on CUPs and rezones. And typically the BZA does on variances. It's not quite that simple, but it's pretty close. And again, on variances, there's a use variance and there's an area variance. And use variances are pretty rare. So next, if you end up not liking the decision, what's your path? They call it legislative versus administrative review. And typically, anything that's legislative comes from the city council. And that's generally more like across the board rules. So for example, if I go to the city of Kansas City and say, I would like there to be 10-foot setbacks instead of 25-foot setbacks for the perimeter of all mobile home parks in the city, I can do what's called a textual amendment to the zoning code, which is often called the Uniform Development Code, Unified Development Code, the Muni Code, the Code of Ordinances, Zoning Code, Planning and Zoning Code, but it's just the code, right? I changed the text. Well, that's across the board. If I change the text, then all mobile home parks in Kansas City can get the benefit of this text. And then typically, if I rezone, then all the people in that area would get, or in that classification, would get benefit on the zoning map. So that's probably not going to happen a lot where you're doing that. If you did, the legislature makes that decision. So it's clearly a legislative decision. But if it's something on a singular property, like a variance, sometimes a CUP, there's a variance like, look, Ferd's property deserves a different setback for X, Y, and Z reason. I got a problem. It wasn't my fault. I didn't cause it. But it's just impacting me. Well, that's pretty much, a one-off decision. And if I ask for a variance, it's generally done by the BZA. But if I could frankly do a textual amendment to the zoning code that happens to only impact me. So in Missouri, there's something called tax increment financing. Basically, it's a subsidy for real estate development projects, and it could apply in theory to every parcel in the state. And there's a voluminous stipulations I'm not going to cover here, but there's one old famous hotel called the Elms in Excelsior Springs, and like Al Capone and his mob buddies used to like rent the whole place and throw these big parties. So it's pretty historical for Kansas City mob. So and it's also just this big, beautiful estate and this huge hotel, and it's really cool. I've been there a couple times, and sprawling pools and flowers and stuff. It's really cool. So the city, it's also an economic engine. So the city convinced the state legislature to do what's basically called a state TIF, or I think it's a super TIF, where the state gives up its sales tax too. But they couldn't make a one-off exception to benefit one business. So what they did was they said, we're just going to make a statutory change to allow all historical hotels that are at least 300 rooms in a town between 26,000 and 27,000, and with a historical designation and a building that is older than 100 years. All projects that fit those criteria are eligible for the benefits of Super TIF. So clearly, by that text amendment, they're picking on and benefiting one property. But in theory, there's a second or third hotel just like the Elms. So I tell you that story to say on the zoning, if you're asking for a rezone or a textual amendment just on your property, it could go either way, whether that was determined whether that should be administrative or whether it should be legislative. And this is for the review, because basically if you got a one-off decision, it's just my property, and if I don't like the result, for example, if the BZA says no, okay, well, that feels like they're picking on me. Well, I should have some rights, and these are rights like a regular, almost like a regular trial. And I get things like I get a notice of hearing, I can present evidence. If the city presents evidence, I can rebut it or cross-examine them. I'm going to be allowed, legal counsel. And ultimately, when it's done, I deserve a written decision, up, down, and with some analysis of the evidence that was presented. That feels fair, right? And then I can go and I can appeal that. And typically in a BZA for variance, if you don't like what the BZA did, you can appeal it, but you appeal straight to the circuit court. You don't appeal to the city council, because this is a process outside the city council. And the circuit court reviews these things either de novo, which basically means like it didn't happen, like a fresh start. It means like new on the record or anew or something in Latin. But on something that's a BZA, they're typically going to review it on the record. What that means is they're not going to let you bring in new evidence, and they're not going to do their own research. They're going to say, let's look at the record. So recently I was working on a case in Indiana, and the previous owner actually appealed to the BZA, but they didn't do a good job at all presenting evidence from the BZA. They didn't even show up, the owner. They sent their park manager. And then, boom, the city showed up, the whole mob of protesters showed up, the city was ready, city's planning staff, and they just hammered this park manager. So the park manager didn't do a very good job. Well, then, it should have been a winning case, frankly. Well, the owner then appealed to the circuit court. Well, the circuit court did not review de novo. They reviewed the record. Well, the record was crappy, because they had crappy evidence. They had a park manager there, no lawyer, no owner, no coaching, no prep. And based on that record, the case was dismissed at circuit court, and they were 0-2, and they lost what I thought was grandfather rights, and they lost their appeal, and it was pretty brutal. So de novo is new. So typically, if it's a legislative-based decision and you don't like it, you can appeal to circuit court. Circuit court says, what city council? We don't care, and they look at it from a fresh start, and they do that to some degree to get rid of the politics, I think. But ultimately, they say, we're the circuit court. We don't care about the city council. Now, it's hard to win those. Typically, the burden of proof is still on the applicant, the plaintiff, us, the property owner. Continuing on with de novo review, again, means new. The court may consider new evidence. So not only do they not really care what the city council considered, they're going to do their own research and they do their own job, frankly. And during this review, the court will basically see if the proceedings with the city council violate any constitutional protections. And this can really happen in one of two ways, facially, which essentially means that the ordinance on its face is unconstitutional. And, for example, if the ordinance says, we don't think you can ever utilize your property for agricultural land, even though you can't plant flowers. You can't do all these different things. It makes no sense. There's no rational basis to just not let you plant flowers on your big property. That's just on its face is unconstitutional. It's an unrealistic restriction. The more common one would probably be unconstitutional as applied, which basically means as it applies to me, the pissed off applicant and plaintiff, the decision is unconstitutional. Now, the burden of proof would be on me, the applicant, and I have to present clear and convincing evidence, which is 51% plus. It's not 100% or 99.99, beyond a reasonable doubt. It's got to be pretty strong, and I need to show that I've suffered some sort of pain, and I have to overcome the rational basis that this government did this for the protection of the public welfare, the health, safety, morals, and welfare of the community. So it can be tough. So that's why you lose on things like fire code, because it's very reasonable to have homes spaced further apart than is likely to cause them to burn one after the other. So again, unlike the de novo review in the legislature, the administrative appeals, like on the BZA, those are really created on the record. So if you do go to the BZA, you really got to make sure you do a good job with your evidence in that hearing. And, you pretty much have to have an abusive BZA to overturn those. I think it's called arbitrary, capricious, and abusive, which basically is the ruling was just crazy stupid. And if there's support of that, then you might be able to win. But if there's not support, meaning that the BZA has any real evidence supporting their input, well, then it wasn't a crazy, stupid decision. It was just maybe it was their opinion, and they're entitled to it. So it's really hard to win against the BZA appeal. They gotta be almost criminal. You got them on tape saying something like, "Yeah, I don't like those stupid trailer parks. I don't care what the request is. I'm going to turn it down." Okay, that's an abuse of power. That's asserting a bias. Now, the downside of this is you don't get to just choose where you want to go, the administrative review or the legislative review route. The process you went through kind of drives that for you. And the process you go through is based on whether, again, you're choosing these three different methods of utilizing your property. You're rezoning, you're requesting a variance, typically through the BZA, or you're requesting a CUP, which, depending on the municipality, could be a legislative city council move, could be an administrative BZA, and then sometimes the BZA, their decision is final. And most time, frankly, that's how it is. It's like an alternative route to city council. But sometimes in some jurisdictions, they've decided to give their BZA, either the state or the city has given the BZA limited powers, and they're just a recommending body. They're basically a plan commission, but for an alternative route, which kind of baffles me. But anyway, that's a couple tactics and a couple just background stories of how to utilize your property in the face of an onerous zoning code, in the face of an obstinate city, or possibly in the face of fact pattern that is not favorable, where you need to go ask for special permission. I typically fight on the grandfather status, because most of the parks I look at are legal non-conforming, and it works better than you'd think. And I've got a more long-winded analysis on that. I should probably do an episode on that. That probably would have been better than this, to be honest. But I'm going to reevaluate how much of that I feel like putting my neck out there so these cities hate me and I get a speeding ticket or something. But anyway, zoning stuff, honestly not the most fun, but it's super important. So I try to keep abreast of it, at least at a reasonable level, and encourage you to do the same. Hope this helped. Until next time, have fun, sleep well, God bless.
You've been listening to the Mobile Home Park Lawyer Podcast with Ferd Neiman. Ready to learn more? Go to www.themobilehomelawyer.com for free resources and materials to help you succeed. If you love the podcast, go to Apple Podcasts, give us your review, and subscribe today. Thank you for listening. Neither the Supreme Court of Missouri nor the Missouri Bar reviews nor approves certifying organizations or specialist designations. The choice of a lawyer is an important decision and should not be based solely upon advertisements.